In your book, Religious Freedom in an Egalitarian Age, you talk about sort of how there's a way to come to non-arbitrary solutions to some of these really complex legal debates surrounding religious liberty. Could you just talk a little bit about what your proposed solution is and how that's different from what other people have proposed?
Yeah, sure. I mean, first of all, thanks for having me. It's really it's great to be part of your program. I am really devoted to Brown, and I owe a lot to the school, both personally, but also in my intellectual development. So it's fun to be involved in this way. So the idea of social coherentism came out of a problem that I saw in the literature, which was that I don't know if you're familiar with sort of legal methodology in general, but there's one branch of legal studies called critical legal studies, which is connected to the now famous and infamous critical legal studies in general, or even critical race theory. But the idea is one that's like quite suspicious about the prospects and possibilities of making rational argument in the law at all. And it doesn't have a particular political valence. So there are, sort of critical legal thinkers on the left, of course, but there are also critical legal thinkers on the right. And at the time that I was writing, there was a particular author named Steve Smith, who teaches at University of San Diego, who was writing from the conservative side and attacking the court's religious freedom doctrines as kind of incoherent. And not just the court's legal freedom, religious freedom doctrines, but also the work of scholars in the field. So he had just published this piece in the Harvard Law Review where he was criticizing Ken Greenwald, who's one of the sort of prominent liberal theorists of religious freedom at Columbia. And Steve Smith's point about Ken Greenwald was, this guy is really smart. He kind of meticulously lines up the arguments on each side of difficult religious freedom debates. But at the end of the day, he just chooses. There's this moment where he just sort of decides which set of rights is stronger or which set of arguments is stronger. And Steve Smith thought this was a kind of revealing moment where Ken Greenwald sort of showed that reason couldn't sort of determine the pathway forward in these debates. And I was troubled by that because I thought that critique had power and no one had really responded to it. And I wanted to figure out for myself what I thought about it. So the idea of social coherence was my attempt to respond to that critique. And the idea is based on, but not fully dependent on an idea from John Rawls, which is the idea of reflective equilibrium. And the sort of thought is that you try to make these cases fit together with everything else that you believe. So when you encounter a new dispute, you kind of look at it and put it together with the ground level judgments that you've made in previous cases, also with the principles that fairly abstract from those judgments. And you endeavor to come to a solution that kind of fits together with your previous convictions that themselves have withstood scrutiny. And when you do that, what you're doing is not arbitrary, but it's a way of reasoning through moral problems and interpretive problems in constitutional law. So I made a case for that kind of rationality as an answer to kind of radical critical thought.
So essentially what you're saying is that you sort of agreed with scholars in the sense that there is sort of like some sort of arbitrariness with some of these decisions, because that's like sort of what got you to think, okay, well, here's a non-arbitrary way to go about it, right?
Right. Well, certainly there has been. I mean, there are lots of moments of contradiction and even just sort of like lack of reason in the court's decision making, for sure, and also the decision making of many scholars. But Steve Smith's argument was stronger than that. His argument was that that's necessary, right? That these decisions can never be sort of supported, but there's always a moment of kind of radical break. And I just wasn't sure about that as a matter of justice, and so I wanted to see what I thought about it. And that part of the book, that first part, the methodology, is kind of a refutation of the idea of necessary radical breaks.
Right.
The social part is sort of bringing in, the fact that these decisions seem to reflect the sentiments of the people, right, in all their complexity and so forth. But it does seem like when we reason together as a society about important questions of church and state and constitutional law more generally, that process takes into account, social mobilizations and political movements. That is, it's possible and even likely that people will be influenced by those kind of movements, but that too doesn't undermine the exercise of judgment that people are engaged in necessarily.
Right. And if you don't mind, could you elaborate more on what social coherence is and how that's different from, I'm ignorant about it. I don't know enough about it yet, but how is that different from sort of like a stare decisis approach to, people generally are going to interpret the rule of law the right way, therefore you should rely on precedent, or, just sort of like a majoritarian confidence in the will of people? How is it different from that?
Yeah, I think one of its strengths is that it resonates quite strongly with orthodox kind of legal interpretation, which is highly analogical, right? So when you see a new case, when the court sees a new case, it asks, well, how does this differ from what we've done in the past, right? Assuming some level of confidence in what we've done in the past, can it serve as a guide to how we should decide this new case? Why should we, use the past as a guide? Well, not in a slavish way, for sure. I mean, we've made lots of mistakes in the past as a society, but some of those judgments have withstood the test of time, right? That is, they've been subject to repeated criticism and stress, and they've changed over time, but some of them have endured, and so they're entitled to not slavish kind of deference at all, but a kind of status as a starting place for thinking about new problems. So one thing I like about this a lot, as I say, is that it does seem to reflect what judges actually do. It's dynamic, meaning that none of our judgments are set in stone. All are subject to reevaluation, but it acknowledges a kind of learning that's social, right? That's connected and networked. Another thing I like about it, just to add one more element, is it's quite similar to the way people, that is, like natural people in their ordinary lives, think through moral problems. They think like, what solution to this problem would, reflect my existing set of sort of beliefs and preferences and what I've done in the past.
Do you think it sort of adds to a predictability in the law as well, so that people can better predict how controversial cases are going to come down in the future?
Yeah, I was going to say, in addition to, sort of trying to behave in a way that's consistent with past judgments, just because past judgments might be correct, it also lends a certain kind of stability to the law and a fairness, right? One reason just to follow precedents is out of a kind of notion of equality, right? That like cases should be treated alike, and also a sense of stability. And look, radical thinkers on the left have criticized stability for good reason, right? This should not be a master norm. However, there's something. Not everything, but there's something to be said for the rule of law and for stability over time, so that legal judgments can be predictable and not dependent on the personalities or whims of an individual decision maker.
Could you give an example of a case maybe in the last 10 years or so that you would consider, like, you can sort of a controversial case that ended up in a sort of predictable way based on your theory?
Yeah. So the set of problems that I was confronting in that book were problems of conflicts between equality law, like civil rights law on the one hand, and religious freedom on the other. And those problems were cropping up in the context mostly of LGBTQ rights on the one hand and reproductive freedom for women on the other. And in those two areas, religious traditionalists were asking for compromises between religious freedom on the one hand and equality law on the other hand that were without precedent, right? We have a lot of experience as a nation sort of thinking through the ways to balance traditional religious judgments against progressive egalitarian norms. And the kinds of solutions that were being called for here were novel, And so from a coherence point of view, that's troubling, right? We need to think of good reasons why we should come up with settlements in this area that are different from the settlements that we've worked out over a period of time in other areas of civil rights law. So, for example, if a baker selling a cake refuses service to a couple that wants to use the cake in a wedding celebration, because they're two people of the same sex, do we have precedent for that in other areas of civil rights law? And one of the burdens of the book is to say, we really don't. Like that would be a new thing in our sort of tradition of settlement between religious freedom and civil rights law, and so we need a good reason for a departure in that area.
So, needless to say, do you disagree with the cake shop ruling?
Well, I actually don't in all respects. The way that case came down was, I think, regrettable because it was kind of crafted by the court as a one-off kind of fact-specific ruling. In some ways, I think it's possible to come up with settlements that are defensible in this area, even settlements that don't exactly reflect, everything that we've done in the area of race. For example, one kind of settlement that's been emerging is to say, well, the institution, the business, has an obligation to serve all comers, but individuals within the business can be accommodated, right? As long as there's someone else there who's willing to serve them, then from the couple's perspective, they're not denied service. It's completely invisible to them that there's some individual there who prefers not to serve the couple. And I think that compromise is defensible, even though it does depart a little bit from what we would do in the area of racial justice, right? We would not tolerate even a single individual within a business kind of exempting themselves from serving, say, interfaith couples or interracial couples, right? We wouldn't tolerate that. But I do think in this area, because of the way that norms have rapidly evolved and also the position that religious believers have in this, there is room for compromise within the kind of framework that already exists. But the way that the baker himself wanted to resolve the case, which was that he and his business got a complete constitutional exemption from having to serve gay people, seemed to me not warranted.
Right. So this is the opportunity to ask about the prayer cases, about the sort of kickoffs to all the school prayer controversy were Engel and Schempp. Could you just comment on sort of how you view those and whether those were rightly decided based on your methodology?
Yeah, so the school prayer cases were, they came down in the early 1960s, and they remain highly controversial, right? So, the Supreme Court is often said to have a democracy problem, right? These are unelected judges who serve for life and who have the power to overturn democratically enacted laws. So how is that possible in a democracy, and how is it defensible, right? And one of the defenses of the Supreme Court is to say, well, although that's possible in theory, in actual practice, the court does seem to sort of hew to public opinion, right? The cases that it's decided do tend to track, the sort of median view of the American voter over time. And sometimes that's a problem. You would wish the court to behave like, more egalitarian manner, but it seems to move quite slowly and behave quite moderately. The school prayer decisions, though, are counter-majoritarian, meaning like public opinion has stood against the school prayer decisions for decades. Not everybody, of course, but lots of Americans believe that those cases were wrongly decided. I actually believe that they're defensible as a matter of political theory and morality because of the ways in which the alignment of public schools with particular religious views and beliefs could work to compromise the political equality of students and families who dissent from those beliefs. So it seems to me actually like quite important from a democratic perspective that those decisions remain in place. However, as a matter of realpolitik, I think it's important to notice that the changing majority in the Supreme Court could portend, some movement in the area of public schooling and prayer. And in fact, there's a case before the court this term that implicates this issue, where not a teacher and not the school itself, but a football coach at a public school engaged with prayer on the football field with the team as a matter of practice. And the court granted cert in that case, which has been kicking around for a long time. So that's a place where the court could start to, not overturn the school prayer decisions all at once, for sure. I'm not predicting that, but could start to make a movement in that direction, right? By biting off a piece of that issue in this very term.
Right. So there are a lot of, I don't want to say like fear mongers, but there are a lot of sort of non-lawyer sort of pundits that keep kicking around the idea that, oh, now with the conservative court majority, we could have a return of school prayer. And a lot of that sounds a little bit unrealistic to me. Obviously, like you said, it's not going to all happen at once, but how would that work? I mean, you said the first step would be potentially the case that they're taking up this current term, maybe having some sort of ruling on that seems to slide against, the foundation of Engel and Schempp and things like that. But then after like a small step toward the return of school prayer, how does that proliferate?
Well, let's take a step back for a minute and think about how the Establishment Clause has changed in recent years, quite noticeably and quite quickly. And the basic change has been from a model of separationism, right? So the government should remain separate from religion. And that's it's a way of thinking about the government's obligation of neutrality in the face of religious differences. The school prayer decisions kind of participate in that model. To a model of neutrality, where the government doesn't have to remain separate from religion as long as it's being even-handed in its treatment of religious ideas alongside non-religious ideas, right? So the way it could happen is, there could be a movement, which is already underway for sure in other areas of Establishment Clause law, from a separationist model to a neutrality-based model. And I think we're already starting to see glimmerings of this in the oral argument in a school funding case this term. Justice Barrett, Amy Coney Barrett, suggested a model like that, sort of saying, well, secular private schools have, values perspectives from which they structure a curriculum, and religious private schools also have value perspectives from which, right? And she was setting up an argument there that religious private schools have a claim to the same kinds of funding that that secular private schools that receive. But you can imagine that kind of argument being, or that kind of model of religious neutrality be extended beyond private schools to public schools as well. As long as the government, sort of recognizes the multiplicity of commitments and convictions that exist in the student body, it can include religious perspectives, including potentially religious prayer in its daily operations.
I see what you mean. So maybe start with the private school domain, then shift toward the public school domain if things were to work out in the conservatives' favor, right?
I think that's a model that's not crazy to imagine. There's another area that's analogous, even before recent changes in the court. The court handed down a decision allowing legislative prayer, right? So a local legislature could, in a neutral way, right, that at least ostensibly includes all perspectives, secular and religious, start its sessions with prayer. And even though the prayer in that case was, overwhelmingly Christian, both in personnel, the ministers who were delivering the prayers, and also in content. But because it was, it was sort of formally neutral, the court said it satisfied the Establishment Clause. That's not a setting that, it's not like public schools where children are involved and impressionable citizens, but you can imagine that model being extended to public schools. I don't know whether that's going to happen. I'm not making a prediction about that, but it's thinkable today in a way that it hasn't been in the past.
And that leads, so the final sort of thing about your work is we want to ask about, this is in reaction to your HLR article discussing Fulton and Smith. Could you briefly comment on whether you think there exists a plausible alternative to Smith, sort of the way that ACB lays it out? Where do you stand on that?
Yeah, so just stepping back for people who don't what we're talking about. This is to do with the main rule for the free exercise clause. And today, the main rule is that if the government regulates in a way that's neutral as to religion, so all citizens are regulated in the same way and religious people are not targeted, then people whose religious beliefs conflict with that regulation do not get an exemption, the current rule in constitutional law. The alternative rule is no, religious people who are substantially burdened in their core beliefs and practices by a government regulation, even if it's a neutral regulation, do enjoy a presumptive exemption from that rule. And there's a significant mobilization on the court, toward this alternative religious exemptions rule. In the Fulton case, the question of whether the current rule, which was set out in this case, Smith, should be overturned, was presented to the party. So it was explicitly on the table. And 3 justices, headed by Justice Alito, said, yes, the rule should be changed. And Justice Barrett, who wrote on this question for herself and Justice Kavanaugh, and in part Justice Breyer, said, we don't really like the rule of Smith, but we have trouble imagining an alternative that would be workable. What would that look like? And so in this Harvard Law Review piece, I kind of take up that question. And usually it's sort of conservatives who think that Smith should be changed and replaced with a rule that allows religious exemptions. But I pointed out that there are people on the left, like myself, who also support that kind of change. And the reason is that there's situations where religious minorities and other kinds of nonconformist believers, need protection even against general laws. That seems like an important function of the sort of protection of minority rights of conscience. And then I set out a way in which that kind of regime that does allow constitutionally mandated exemptions from general laws might work, right? And might work even for people who believe that civil rights laws, for example, sort of are driven by government interests of the highest order and really should not admit religious exemptions. So I set out the ways in which I think that could, kind of speaking not just to Amy Coney Barrett and other justices on the right who agree with her, but also to justices on the left who might be attracted to the idea of religious exemptions under the Free Exercise Clause. Thanks for unpacking that, because it's a complicated question, and it's just really complicated part of law, right? That whole controversy. Last comment on your work before I ask you some more personal questions. What is sort of, and this is pure speculation, but what is sort of your prediction on whether or not Smith officially gets overturned? I really don't know. I don't think prognosticating is one of, our strengths as academics. In fact, it's been shown to be, a weakness. I think we're much better suited to sort of constructing arguments on how the Constitution ought to be interpreted and trying to persuade people that those arguments are well-grounded and attractive. And so I really don't know. I mean, I can say with some confidence that the rule of Smith will be kind of weakened over time, but whether it's overruled outright or whether the court continues to kind of chip away at the rule of Smith, I think is unclear. The chipping away is really showing its strain, right? I mean, the court has been engaged in that process for a few years now, and it's resulting in all kinds of contradictions and complexities, as I try to show in the case. It means that the court has handed down decisions that really don't cohere with one another, right? So it's becoming a little embarrassing for the court. I think it would be better if the justices could step back and kind of make a clean start on this issue. No, it's a great response. So now we'll just talk a little bit about starting with your days as an undergrad at Brown. What were you sort of envisioning as a potential career, and how did that evolve to the point where you found yourself at Yale Law School? So I was majoring in religion at Brown, and also in modern culture and media, as it was called at the time. So I was interested in questions of power and justice, both within social movements that were connected to religion in one way or another, and also in the culture more generally. And I pursued that interest ultimately in a thesis about South Africa, which was at the time nearing the end of the apartheid regime. And I was fascinated by the ways in which the apartheid regime had been both defended using, Calvinist theology, but also critiqued using the very same theological tradition. So that was like a fascinating problem to me of interpretation. Like, how could it be that the very same theological tradition was being used, in polar opposite ways from different social locations? And I ended up, after Brown, traveling to South Africa on a Fulbright and studying that question at the University of Cape Town, and kind of getting really interested in it. At the same time, I was pursuing graduate studies at the University of Chicago in religion. So I knew I was interested in religion from an academic perspective, and I was interested in the academy, as a profession. I loved ideas when I was at Brown, and I continued to, sort of thrive in that world. But I thought at the time I would teach religion. But while I was in South Africa, I met a bunch of young lawyers who were engaged in kind of thinking about what the Constitution would look like under a democratic regime in that country. And I found those people really engaging and exciting. And I also liked the ways in which they were able to think kind of from a explicitly normative and political perspective, which is not something that there's really place for within the field of the academic study of religion. So I was kind of moved by that experience, not just the sort of content, but also the ways in which these people were fashioning their lives. And increasingly, when I returned to the University of Chicago and continued with PhD studies there, I was sort of worried about the ways in which teaching religion would kind of narrow my focus and make it harder for me to engage in practical social problems like the ones that I had seen in South Africa. So it was during that time that I kind of started to think about law school, both because of my personal experiences and also because of the worries that I had about what a career teaching religion would look like. So I applied to law school and worked hard on that project, and then when I got into law school, I went, even though I hadn't finished my PhD at that time. So I went to Yale Law School, and my thought was I could write the dissertation while I was there, but it turned out that law school was pretty demanding. I didn't really allow for that. So it wasn't until after I completed law school and started teaching, actually, that I found the time to sort of wrap up the PhD. So in retrospect, my path kind of looks coherent, but at the time it had lots of twists and turns, and it was not clear, how it would turn out. And I guess I would just encourage people, who are in their 20s and sort of working their way through some of these career decisions to remain somewhat open and flexible and, responsive to information that you get about your own interests, but also about, the opportunities that are around you.
Did you consider dropping the PhD just altogether while you were in law school?
I did, and I didn't need it after a certain point, because you don't need a PhD to teach in a law school. And lots of people who I was at law school with were in the same position. They had started PhD programs, and many of them dropped them. So there wasn't really a reason for me to continue, except that I wanted to. I just I liked the feeling of completion, and I also like the interdisciplinary sort of authority that it gives me, right? The ability to sort of work not just within law, but within other disciplines as well. And that's turned out to be really important and great for me.
Right. And while you were, during those 3 years, were you thinking already at that time? I mean, I think you've alluded to this, but you were thinking, I want to teach, even though you went on to go into private practice for a little bit afterwards?
Yes. When I entered law school, my thought was that I would teach, probably in a law school if I could, or else again in a religion department. But increasingly, I was thinking about law teaching. So that shaped my decision making, because I knew that in order to teach in a law school, I'd have to go to a law school that was excellent. Because the legal academy is just very hierarchical. And standardized tests they didn't come naturally to me. So when I was living in Hyde Park in Chicago, I remember not only did I take the Kaplan LSAT, course, but I also took every practice test that was available. And so every day after I finished, working in Chicago on religion, I would take the bus to Midtown, or like it's called the Loop, the downtown Chicago, where the Kaplan Testing Center was, and I would take tests, and they would evaluate me, and then I could use that information to improve. And so I worked very hard on the standardized testing part, and I think that ended up being important.
No, I bet. I mean, it's no small endeavor to get into Yale Law School, that's for sure. So it's interesting that you ended up in private practice for a little bit. Could you sort of like justify why you went that direction for a little while?
Yeah, I mean, some of it was pragmatic. Like I borrowed every cent to go to law school, including living expenses. So I had a huge debt when I came out. And even though Yale Law School has, generous loan forgiveness or loan repayment programs, they're all ex post, right? So you first rack up all this debt, and then they help you repay the loans, which is a very uncomfortable position, I thought. Yeah. So that was one just very practical reason. But also I was interested in the life outside of the academy. And one of the things that's great about law school is it does give you an opportunity to work in lots of different worlds, right? So like you are now credentialed to work in, a Wall Street setting, and you're also credentialed to work in a government setting, and in a nonprofit setting, and in an educational setting, right? So that's something I love about the legal profession. And I would encourage your members who are thinking about law to explore some of that diversity, right? Because being a lawyer it almost is meaningless. Like there's so many settings in which you can practice law that it's sort of hard to speak in one voice or with one voice about all of those settings. And I really enjoyed it. It was an amazing experience to work in a private firm and then also work for the ACLU litigating cases. And those were very different experiences, but both very valuable. So I enjoyed that.
Did you ever consider just dropping the teaching dream and just staying with litigation and with private practice?
Of course I considered it. I mean, it's an attractive, both of those are attractive, ways of life. And I have friends who did, who pursued them and are still working as partners at Davis Polk and Wardwell, where I was, or Tebbe and Fulton and so forth. And, I can understand that decision. It ended up not being for me for a variety of reasons, but some of them were very personal. Like I just didn't, the lifestyle wasn't really like suited to me. I needed more autonomy and so forth. And then the ACLU, which was an amazing experience, for someone like me who didn't have independent resources, just didn't pay enough. Like I couldn't make a life that way. So there were lots of different reasons why, I didn't end up practicing law full time. Although I do consider myself to be a lawyer. I mean, I'm still a member of the bar and I still file briefs regularly. But that's not my full time profession.
And could you just talk a little bit about your clerkship and how that affected the trajectory of your career? I know there's sort of repetitive questions about how did this affect, your decision making, but you had a very high level clerkship.
Yeah, so I clerked for Judge John Walker on the United States Court of Appeals for the Second Circuit, which, for those of you who don't know, is an intermediate appellate court in the federal system. And that was a difficult clerkship to get. I was happy to get it. But what made it great was the experience itself. I mean, working, in close quarters with a federal judge who's been nominated by the President of the United States and confirmed by the Senate, and is given, incredible responsibility to decide cases, the vast majority of which are never appealed to the Supreme Court, is a great experience. And you can see how a public servant like that works at a very high level. And you also get to engage with a broad range of legal questions, which is really exciting and something you really don't get to do as a professor because, as interesting as this job is, you do specialize to a certain degree. But clerking, you're dealing with securities law cases and criminal law cases and immigration cases. And, it's just an amazing experience. So I recommend that experience, not really for its instrumental value. Like, I don't know that it helped me get a job afterwards, or certainly not for its monetary value or anything like that, but just because it was fascinating and fun. And it also is a chance to, for those of you who are patriotic, it gives you a chance to serve your country in a way that I think is, meant something to me.
No, that's really cool. And so you got it while you were at Yale, and then, okay. And you said you fought for that really hard, and you just mean, sort of the application process and just fighting for your grades and interviewing and all that stuff?
Yeah, I mean, for people at Yale Law School, it's pretty easy to get jobs. Like it's not that difficult to get a job at Davis Polk or even the ACLU, but to get a clerkship is still really hard. So you need to, kind of put your mind to it. And, now that I'm a professor, I help my own students do that. And we work really hard at Cornell Law School to educate students about clerking for judges, and then to help them find their way to the right judge. And that can be a very kind of individualized, customized experience. But we've been very successful. And so many Cornell law students have clerked for federal judges and state judges at a very high level. And we're really proud of that. And I think it's been a great experience for them.
Did Judge Walker give you significant career advice while you worked with him, or not really?
Yes. Yeah. He's been a great mentor, and he still is. We're still in touch, and he's amazing at that. Not only that, but you then get connected to, a family, a community of people who have clerked for him. And there are lots of people like that now because, he's been on the bench a long time. And that's a wonderful resource too.
That's what I thought. I thought you would have drawn from that connection, because you're right. I mean, it's hard to get, and then it puts you in a circle of really elite people that presumably all share at least some of the same goals, some of the same characteristics. So it's a huge network to pull on. So then I guess our finishing up question here is just, what is your advice for students who, there are a lot of students at Brown that are thinking about law school but aren't sure that they're sort of fit for it, or that it's worth them pursuing, especially nowadays, as so many of the Ivy League goes into consulting or investment banking. It's sort of difficult for some kids to understand why pursuing 3 more years of school, potentially getting themselves into debt, is worthwhile if they don't feel like they were born to be a lawyer.
So I do have some thoughts about that. It used to be the case like a generation ago that if you were smart and you wanted to be a member of the American elite and you couldn't stand the sight of blood, law school is kind of a default. And I think that's changed, as you say, it's no longer the case that people who don't know what to do will just sort of take the LSAT and go to law school. And I think that's a good thing, because it didn't really work as a default, right? Like a lot of people ended up in law firms who were not really well suited to it, and they were unhappy. And so there was a real happiness problem in the legal profession that was, I think, closely tied to its sort of status as a fallback for students who didn't know what else to do. That's a good thing, I think. But it does mean that students will affirmatively choose law, and why would they do that? Well, I think one reason they might do it is because first of all, they are interested in commerce or in finance, but they're not numbers people, right? So they're interested in the way that the financial system works or the commercial law system works, but their minds are more analytic and discursive than they are quantitative, right? Moreover, they may have a risk profile that's different from hedge fund managers who have to be able to tolerate lots of risk, whereas lawyers, may not want that kind of risk. And I have friends who have worked at Wall Street firms for their whole career, and they make plenty of money, comparable to most people in finance. But they are engaged in a different kind of work. They're advisors to companies, right? And that advisory role can be really fulfilling. It can be great for the right kind of person. So that's one path. But another path I think draws at least as many people, and maybe more, is people who are public minded. Right. And so people who want to serve their communities, either through government service or through public interest work at organizations like the ACLU or a million other kind of public interest nonprofits, both on the right and on the left, by the way. Those people can be very well served by going to law school, because look, what we're engaged in law schools is the pursuit of justice. That's what the endeavor is, right? And so if you're interested in that, right, and you want to make arguments that are tailored toward and point toward, the pursuit of justice, as cheesy as that sounds, like that is actually what we're doing. And so I think students like that would be well served by thinking about it.
That's a really comprehensive answer. Like you said, it's sort of a generational difference. Kids are having a harder time sort of deciding now to do it than maybe they used to, because it was such like a commonly accepted default, like you said. But especially at a place like Brown, right? Like kids are studying all sorts of things. Like there's such a breadth of academic diversity.
Right.
I think the kids that are doing stuff that's more obscure. I mean, you did modern media studies, which is one of the relatively more obscure ones. I think especially those kids have concerns about, well, am I really fit for law school? Like I have those same ambitions, but maybe I'm not fit for it because I didn't take the right concentration.
There's a kind of political and social consciousness that's, present among many of the student body at Brown that is well suited to, right? So if you're interested in politics or you're interested in questions of justice, it does make a certain kind of sense. And it might even make sense for Brown to, start a law school. Thank you so much for doing this.
Of course.